Welcome, everyone. My name is Howard Gould, and I am co-chair of the real estate section for the Beverly Hills Bar Association. It's a great pleasure to have all of you join us for our program on like-kind exchanges today. Before we begin, let me give you a brief update on our upcoming programs in case you're interested in some of these. A week from today, on April 23rd, we're doing our annual review of the prior year's real estate cases, presented again by Lawrence Jacobson, and that'll be moderated by Elizabeth Dryden, my co-chair. On May 21st, we're doing a program we haven't ever done before on landlord insurance coverage for habitability claims in landlord-tenant disputes. Former president of the Beverly Hills Bar, Steve Raucher, who's an insurance lawyer, is going to give that presentation. On June 25th, Brian Mashin's coming back. He lectured the last couple of years on the AIR lease forms and purchase and sale agreements. And this year he's giving us a different program about how you effectively represent the small tenant in negotiating commercial leases. And I'm sure Brian will have some interesting insights about when you're representing someone who would appear to have less leverage than the landlord that they're dealing with. We're open for the July at the moment and have no program planned for July, but we've already doubled up a couple of months this year with programs. And August 20th, we're doing a program on the revisions to Code of Civil Procedure Section 664.6, the settlement provision that allows a court to dismiss a case but retain jurisdiction. There have been some important changes. Some of those apparently have special effect on probate matters. Scott Ron will be presenting that part of the presentation. He and one of his colleagues have written an article that was published on that. And Alphonse Provinciano, who's going to be our incoming BHBA president, and is a family law lawyer, is going to talk about some of the things peculiar to family law, since so many real estate matters end up going through probate and family law. And those settlement procedures apparently are some important changes. A couple program notes for today. We use the Q&A for questions, so please put your questions in the Q&A, and those will be followed along and answered as possible during the program. The chat we don't use the Q&A for that, but you will find a link to the program materials in the chat if you haven't already accessed those. Finally, your MCLE certificates go out very promptly from the Beverly Hills Bar. They're very efficient about those things, so you should look for that shortly after the program. It's a great pleasure to have Howard Fisher with us and LaVonne Lawson, both of whom have assisted at times on our executive committee for this real estate section, which we very much appreciate, and offered to do this program for us. They're both former presidents of the Beverly Hills Bar, so we're very well represented here. Howard is a principal at Fisher & Fisher in Beverly Hills, where his practice focuses on tax planning, business and commercial transactions, real estate, and trust and estate matters for high net worth entrepreneurs and their families. He's a past chair of the California State Bar's taxation section, a past president of both the Beverly Hills Bar Association and the Beverly Hills Bar Foundation, and he co-founded the UCLA Tax Disputes Institute. Howard has published more than 30 articles and has spoken at over 140 conferences around the world. He's also co-author of It Wasn't Raining When Noah Built the Ark, which is a treatise on asset protection, and he has also assisted with revisions of the first two volumes of Rhodes' Income Taxation of Foreign-Related Transactions. He currently serves as elected treasurer of the city of Beverly Hills and has held other positions there. His education, he studied at the American College in Paris, received his bachelor's degree from USC, studied law at Southwestern University and the University of Cambridge in England, where he received an LLB with honors. And he completed postgraduate studies in international business and taxation at the Harvard University Law School. LaVonne Lawson is a shareholder at Leech Tishman, where she advises businesses and individuals on federal and California state tax matters, with a focus on tax reporting and compliance, tax controversy and tax litigation, and estate planning. Before joining Leech Tishman, LaVonne served as a senior attorney with the IRS Office of Chief Counsel, where she represented the agency in U.S. Tax Court and advised Department of Justice attorneys on tax litigation matters. She worked also at Pillsbury Winthrop and also had her own law office of LaVonne Lawson for some period of time before joining Leech Tishman. LaVonne received her BA in economics and English at Stanford, her JD from Duke, and also an MBA from the Duke University Fuqua School of Business. And it's a great pleasure to have both of them here. And LaVonne, the program is all yours now. Thank you very much.
Well, thank you, Howard Gould, for that kind introduction. It's much appreciated. Hello, everyone, and welcome to this BHBA program on navigating like-kind exchanges in California. I'm looking forward to presenting this with Howard Fisher. So again, thank you. This can be a complicated area, or certainly contains a number of moving pieces, particularly with respect to the state of California treatment. And we appreciate this opportunity to review the topic. So Howard Fisher and I are going to start with the federal statute, and we'll review some of the basics, and then we'll turn to California and discuss places where it does and does not conform to the federal statute or procedure. And then we're going to cover some areas that may require some additional compliance or involve additional scrutiny, again, from the state of California in particular. So that you know where we're going, you will find our roadmap on page 2 of the PowerPoint. We'll try to follow the PowerPoint, though for your reading pleasure, Howard has provided an extensive outline covering what we discuss here and more. So much has been made of this one sentence rule set forth at IRC section 1031A. No gain or loss shall be recognized on the exchange of real property held for productive use in a trade or business or for investment if such real property is exchanged solely for real property of a like kind, which is to be held either for productive use in a trade or business or for investment. Taxpayers have been able to defer tax on exchanges of like-kind property since the Revenue Act of 1921. So the concept has been around for quite some time. But the statute, Section 1031, was most recently amended pursuant to the Tax Cuts and Jobs Act of 2017, which limited the type of property eligible for like-kind treatment to real property. We'll discuss later what constitutes real property for these purposes, and I'll note that Treasury regulations addressing the definition of real property were submitted in 2020. But prior to this time, taxpayers were able to exchange personal property in addition to real property as long as it met other requirements of the statute. Now, as I noted, California, we want to look at places where California does and does not conform to the statute. Well, California did not initially conform to the statute. So until essentially 2025, when a change made in California statute in 2025, taxpayers with AGIs for an individual up to $250K, for joint filers or head of household up to $500K, taxpayers for California purposes were still able to exchange personal property, but that changed pursuant to the change in the California statute under Revenue and Taxation Code 18012 back in, or I think it's 180.1.5. I'll have to look here at the here we have it here, our conformity statute. So 18031.5, where California fully conformed to the federal. So now we're looking for federal purposes and for California purposes, we're looking at both, at federal property. So there's going to be automatically be exclusions for purposes of the statute. As you can see on your handout, for instance, certain equipment, aircraft, artwork no longer qualify for federal treatment, for treatment under either for purposes of the statute. So if you could go ahead, Suzanne, and go to the next page.
And where this comes up in pure real estate context is things like hotels, hospitals, where you have a lot of tangible personal property, where in the past you would be able to fit these into like-kind exchanges. You no longer can.
Mm-hmm. And we can't make assumptions about California conformity. And Suzanne, this is the next page where it talks a little bit about real property. Thank you very much. So as I noted previously, and you find in other areas as well, while California confirms with respect to like-kind treatment with some major exceptions that we'll discuss, we can't make any assumptions. So we just kind of have to keep up with the statute. And as I indicated, they didn't conform until 2025 with respect to the change for real property. So so Howard brings up the point of what constitutes real property. And actually we have received guidance pursuant to Treasury regulations 1.1031-A, and I think it's actually 3 also is where they describe what constitutes property for these purposes. And the definition is quite broad. As you know, and we've listed some cases further on in the outline, federal typically looks to the state for what would constitute real property. But in addition, there have been further examples of property that would constitute real property for these purposes. So at the statute, real property includes land and improvements to land, unsevered natural products of land, can include water and airspace adjacent, certain improvements to land, and certain intangible assets such as, say, fee ownerships or leaseholds. So one really needs to look to the statute, but it's comprehensive. And so while California does in fact have its own definition of real property, for these purposes, we would anticipate California conforming, as they conform generally to the statute, to the federal definition of real property for the purposes of the statute. Howard, did you have any comment?
Yeah, and it includes some odd things like, for example, there's a couple of private letter rulings on transfer of developmental rights. You know, if you limit development on property A that you own, you may have rights to have added height or density that you could sell. And those are treated as real property, at least by a couple of rulings. Things that are attached to property in a permanent way, wharfs, for example, roads and utilities, things that are components within buildings, elevators, HVAC systems, things that are attached to the real estate are considered dirt for purposes of like-kind exchange. Co-op shares are treated as condominiums in California, and that's treated as real property, even though it's technically an intangible. What is not real property is a partnership interest. What is not real property is a real estate investment trust. Now, there are techniques that if you have real estate and you want to go into a REIT, it's called an UPREIT transaction, where you would take your real estate, contribute it to a partnership. For the REITs in a partnership format, you just contribute it directly and get a REIT share, and then it would come under Section 721 of the Internal Revenue Code and the comparable California statute. But once in a REIT, you can't get out of a REIT very easily. It's almost impossible. So, go ahead.
No. I'm sorry, I didn't mean to cut you off. So for purposes, again, it's an expansive definition, and Howard, those are very good points about what's not included, and also not included is no stocks, bonds, notes, indicia of indebtedness. But certainly, with respect to, I think, Howard, you bring up very good points about interests in real estate and what would meet the test and what would not. Also on the handout, we note again it seems pretty expensive what can be exchanged. So, for instance, unimproved land for improved land, fee interest for leasehold. But I think there's a huge distinction that should be noted between domestic and foreign property. That you can have real property that's domestic and real property is foreign, but they cannot be exchanged, or they can be exchanged, but they cannot be exchanged and receive treatment under Section 1031.
So your foreign condo has to be exchanged for a 30-year foreign lease, but you can't go from foreign to the United States, for example.
Absolutely. Very good point. So foreign to foreign or domestic to domestic.
Before we get off this slide, LaVonne, it's titled held for.
Oh, we're going back, Suzanne, to the prior. There we go. No, go forward back to the real topic.
There we go. Held for. And held for, again, are those tough words. It comes up twice in the short sentence. It has to be held for trade or investment, and you have to acquire property held for trade or investment. Well, what does hold mean? How long do you have to hold? There's one of the seminal cases is noted, the Blocher case. Joe Blocher was married to Christine Onassis. He was a real character. And he held property, received it, and then gave it away or exchanged it out very shortly after he acquired the exchange property. And the service came in and said, you didn't hold it. Well, there is no holding period. There's been attempts at statutory definitions of either 1 year or 2 year, and those statutory attempts have gone back 30 years, and none of them have ever passed. So we're down to this very nebulous, how long do you have to hold to show that your intent was to hold?
That's a very good point. And it seems that the real meat and potatoes is in the issue of intent itself, right? There's been, I guess, a fair amount of controversy with respect to whether something was really held for purposes of, trade or investment. So, for instance, there is the exclusion for property that is held for sale, right? That wouldn't be for purpose. If it's primarily just simply for sale, that wouldn't meet the test of within.
That's your inventory.
Right.
That's your person who buys a home, fixes it up, and flips it. That's inventory. And yet most of those folks tend to try and claim either capital gain treatment or exchange treatment, and they shouldn't.
Howard, I have a question here. I don't know if we want to look at it later or now. It simply says, and it says collection of DSTs to roll up office building.
We'll get to Delaware Statutory Trust in a little bit because I want to explain what they are.
Absolutely. Very good point.
In terms of this holding, another technique that's real common is I have a house, I've outgrown it, I want to exchange it. Well, we can't exchange homes anymore like you used to in the old days. Right. So what do? You convert it to a rental, and at some point you then could do a like-kind exchange. And maybe after a few years of renting out the exchange property, you move back in it. That'll work. Well, how long do you have to go at the front end, and how long do you have to go at the back end? People like me who tend to be aggressive may say you have to go at least over a taxable year. Other people are saying 12 months or 24 months. The Franchise Tax Board has been very aggressive on the audit side. You want to talk about that a little bit, LaVonne?
About the audit, I think I'll discuss that a little bit later when we're talking about indicia and so forth.
But FTB kind of says if it's less than 2 years, they're sort of taking the position that you haven't held it for the appropriate time period.
The 12-month and 24 months seem to be a common time period regarding the statute. We'll get to related parties shortly, but 2 years is a very important period of time. And so, that certainly sounds about right. So while it's not clear how long you have to have held it, I feel comfortable with that notion of at least a year or two, because we're running into that for purpose of enforcement in the statute. And so regardless of the property types involved, what we see is that the exchange rules require that both the relinquished and replacement properties are held for productive use in a trade or business or for investment, not primarily for sale. And the test rule is going to be applied at the time of the exchange. And both the IRS and the FTB, they have a multi-factor test that they would review for purposes of this issue. And we talk about sort of indicia like kind of documents that you may want to hold to prove your intention previously. And Howard here has discussed here the time period. Are we okay with this one, Howard? Was there anything else on this? I definitely agree with you. FTB scrutiny just in general. Like-kind exchanges are scrutinized. I don't know if every like-kind exchange is scrutinized, but like-kind exchanges are scrutinized. And this may be a time to mention actually, and thank you, Howard, a little bit about reporting. So for federal purposes, when a taxpayer engages in a like-kind exchange, and they will submit a form 8824 with a return. Okay, thank you. I like prompts and all sorts of things. And that's for federal purposes. And with the federal, that's great. I mean, you've met your requirement, and then finally, when it's time to recognize the tax at some point in the future, then you will do that. The income at some point in the future, you will do that. For California, there's more involved. We'll talk about that shortly, but just to point out, they pay a lot of attention. And there's also a memorandum of understanding typically between the federal and states, and certainly between the federal and the California. So one would imagine that they'd be aware of the forms 8824 that are getting filed on the federal side. With respect to California, and there's a big issue regarding exchanging for out-of-state property that we'll get to. But for now, let's just say that this is just kind of a vanilla exchange. It's all in state. And the person themselves is a resident. So for those purposes, what you're initially having to deal with is the issue of withholding, because withholding would typically be required with respect to the sale or exchange of real estate. But if one files a California Form 593, Howard, do you have a prompt for? No, okay.
No.
So one could file the Form 593 and provide information certifying that this is anticipated to qualify for non-recognition as a like-kind exchange. And in that instance, one would not have withholding. If there is boot, and we'll talk about boot shortly, but if there is amount to be recognized, 1,500 or more, then there would need nonetheless to be withholding on that amount. But certainly, as Howard noted, there is certainly scrutiny with respect to like-kind exchanges. I think we can go to the next page. And Howard, did you want to talk about that AB at this point, the proposed? Is this a point to talk about it or not really?
Sure. There's a proposal that seems to be stalled at the moment in the California legislature that would deny like-kind exchange treatment to professionals who are buying up single-family residents. So if they have more than 50 single-family residents, they would be denied like-kind exchange. Sort of a useless provision, because at least the draft legislation doesn't have look-behinds the entity. So you would take a very large organization, they might simply set up dozens of LLCs and have the ownership structure such that none of them own more than 50 of these homes. And so it's going to have no real impact other than just a trap for the unwary. But what it points out is that a lot of states are looking now at things to tax and ways to tax transactions, which they never did before. New York wants to now tax second residences. So if you have two homes in a state and it was worth more than a couple $1 million, they want to put a surtax on it. So we're going to see a lot of these sort of local, state, and even local taxes, some of which may not be exempt from tax through a like-kind exchange, and that becomes a problem.
Suzanne, could you take us to page 3 just briefly? I think that's where that proposed was. Okay, so go back to the AB. Was that the next page from here, Suzanne? Okay, thank you. Stop there. Okay, so this was, this proposal is 50 more or more residences held. And if one reads, go ahead and read AB 1611 with one's free time, because there's probably information there with respect to also kind of the thought process with respect to this, but it just does seem like there's also scrutiny with respect to maybe kind of large holders of single family residence and so forth. So it's kind of an interesting issue. And we'll go forward from here. So Suzanne, let's go forward. All right, delayed exchanges, Starker's legacy. So who was Starker?
Are you asking me?
Yes, I am.
Starker was one of those situations, be careful what you wish for. Mr. Starker had a loss. And remember, 1031 says no gain or loss will be recognized if. So he had a loss and he wanted to recognize it. So what did he do? He broke up his exchange by a few days. He didn't have an exchange. He had a sale, had an intent to acquire property, and he did it in 2 steps with about 4 or 5 days gap. And he said, no exchange. IRS wanted to nail him and said, no, you can't take the loss. They litigated and the IRS won. The court said exchange didn't have to be simultaneous. And next thing you know, smart tax planners said, oh, look at that. We don't have to be concurrent. It could be separated as long as there is this intent. And so Starker ended up kicking the IRS in the head, which ultimately led to some safe harbors, which ultimately has led to the regulations and some restrictions, if you will, or some safe harbors, which is what LaVonne's going to now talk about. But that's how we came to delayed exchanges.
Okay.
You want to talk about them, or do you want me to
I
keep
think that was you, actually.
Oh, all right. And so what we now have is when you get ready to do your exchange, you could go and use what's called a qualified intermediary, which is an entity that shouldn't be an entity you own. It shouldn't be a lawyer or an accountant who you worked with. There are plenty of commercial exchange companies out there, and you give them the property. They effectively sell it. They sit with the money, and they ultimately will acquire the property you want. Well, what property do they buy? You have 45 days to identify the target properties that you want. And it's a hard deadline. It's 45 days, period, not 46. And within the 45 days, there's 3 different rules, although mostly people use the first 2. It's either 3 properties, any 3 properties. So you have to go out, find the property you want, acquire the property you want, or designate the property rather. And it's a general designation. It's the street address, it's the APN, it's a legal description. It's something that identifies the properties. And you could pick any 3 properties. So since you have a short window period, you really have to know what you want. You have to be looking for it. You have to kind of tie it up in escrow in that window period. Otherwise, you may not be able to close in the timely period, and you can't go back and redesignate. The second alternative is not a limitation on properties. It could be as many as you want, but it has to be 200% or less than the fair market value of the relinquished property. So you can't go and identify hundreds of properties, but you could identify a fair amount of properties. And the critical thing is you have to close within the sooner of 180 days or the time when the tax return is due, plus the extensions. So it's a practical matter. It's a 180-day rule. Are there exceptions to this? And the answer is no, comma, unless. And the unless is if there are certain situations where the government has recognized them and has allowed a longer period of time. This happens about once every year or 2. It happened during COVID. It happened during some flooding and fires in 2023. It happened with the Palisades fire. The IRS issued an announcement, in that case was 25-1, which said we're going to suspend these periods for X amount of time. Be careful. California doesn't always follow the feds. So you got to be careful and make sure that you have extensions on these time periods, both for the feds and for the state. Now, what's happened is a lot of times you can't quite find what you want. So there are opportunities that are being marketed out there. It used to be tenants in common were real common, these TIC operations. And now we see the DTS or Delaware statutory trusts. And what are these creatures? They tend to hold larger real estate they fractionize the interest. So you may have a large apartment complex or a large office building that's being held in a Delaware statutory trust or a tenants in common arrangement. And the IRS has said to the DTS that we're going to treat them as an indirect interest in real estate, and you can do 1031s for them. There's a revenue ruling, 2004-86, which outlines Delaware statutory trust. And there's a similar ruling for tenants in common, although the TIC one is a little bit squirrely in that it limits it to 35 investors, and each investor has to sign off on major decisions, which makes it somewhat dangerous that you have one of the investors decide they don't want to do something and you have problems. DTSs is what I'm seeing a lot of, and they're being marketed as just opportunities. So if you start hitting your 42nd day and you don't have anything that lined up, it's pretty easy to find a DTS and designate it.
Now, Howard, I'm finding here we have a Q&A. The LLC, a person's asked, is LLC owner, does it still get 1031 advantages? And, it would seem to me that this is different than the situation with a true partnership or with an entity where, in this instance, we basically have a disqualified entity. So it would seem that disregarded entity. So I would think that the LLC owner, if is not otherwise, if he's only being treated as disregarded entity, would be able to take advantage of this with respect to the property.
Sure. I mean, this is fundamentals. You always go back to very basics whenever you do your analysis. What is the LLC? It could be one of three things typically. It can be a disregarded entity, in which case it's disregarded. So it doesn't exist. Make sure it's disregarded for state purposes as well. You could have two or more members, in which case you may have a partnership or you may have a corporation.
Yes.
So what is the creature? And that's going to depend or then tell you what you have to do. If you have a partnership, then you can't directly engage in a like-kind exchange. And at some point in a few minutes, we'll be talking about what you do in the case of a partnership interest that you want to exchange.
Okay. So let's move forward to reverse and improvement exchanges.
Okay.
Okay.
Reverse exchanges. These have been around for about 30 years now, almost as long as we've had Starker exchanges. And this is where you find property that you want to buy before you've had a chance to get rid of the property you have. Or the improvement exchange is where you find a lot out there and you want them to build typically a custom facility on it, and you want to exchange into it, but you haven't sold your property yet. So this is where you get into these reverse exchanges. And like I say, typically it's where there's property that's either very specific that you need, or it's a very hot property that you know is not going to be on the market for very long, and you want to tie it up. Whenever clients come to me, I try and get them to do the more classic approach, tie up the property with an option or something, and then do a traditional exchange, because you'll be in better, a pathway more traveled and less likely to be risked. Because the reverse exchanges are governed in part by a revenue procedure, which creates these parking structures. And California hasn't always gone along with the IRS on these. And effectively what you do is you go to a qualified intermediary and you have them set up an LLC because they don't want to take the risk of property ownership. And this entity that they set up is known in the trade as an EAT, or an exchange accommodator title holder. And they will acquire the property that you want, the target property. Well, where do they get the money to do that? It's not easy to get financing. Has been one of the classic problems in these reverse exchanges. So a lot of times the property owner are going to have to help front enough cash through other sources, like your line of credit, to have the EAT acquire the target property. then you go out and sell your property, and then you engage in the classic exchange with the ETA. And this all has to be done within 180 days. Under the RevProc, there's a case, the Bartel case, which says, no. 180, it was a guideline for the IRS. It is not statutory, and therefore you don't have to do this within the 180 days. Go outside of the 180 days, the IRS may not be kind to you. And California, the Bartel case doesn't apply to California. So we don't know what California will do. When it comes to improvements, again, you have to do this all within 180 days. So very few improvements are going to be built in a 180-day period, unless it's like a prefab structure that's just plopped onto the property. So what you do is you end up having to prepay these various contracts with the developer, for example, of the property, so that when you get the exchange property, it comes with these contracts prepaid, and there's a risk. There's a risk that you've paid them and they're not going to fulfill their contract ultimately. So it becomes a potential issue. Ready for the next slide, LaVonne, unless you have comments?
Yes. Let's go to the next slide. Let's talk about boot and basis and go from there. And
okay.
So I'll kind of lead off kind of the basic boot and basis rules, and then Howard, you can kind of let us know what happens when we start introducing debt to the whole process.
Okay.
Wow. But as we had noted previously, to the extent that we have property that does not qualify, then we have recognition of gain. Or in like kind exchange, gain will be recognized to the extent that there is boot received beyond the like kind exchange property. So for instance, boot would include certainly cash, and the amount of the cash received. It would also include property that received that did not qualify. And in that instance, the gain would be recognized on the fair market value of the property that was received. You can also have, for instance, let me move over, talk about mortgage offset. So for instance, if what happens with mortgage boot? This was kind of your note here. Mortgage boot given offsets mortgage boot received. So
Okay.
Go ahead. Sorry.
I've always been very simple when I look at these analysis. Yes, you can go to the 8824, fill it in. There's a bunch of worksheets to help you figure out what the gain is, potential gain. But if you get no cash out, you get no consideration out, that's your boot. And then on the debt side, your debt, as long as you have the same amount of debt or you go up in debt, doesn't have to be on the same terms. You could have fixed mortgages, you could have and switch into a variable mortgage. You could have short-term mortgages, long-term mortgages, doesn't matter. Debt is debt. It has to be secured by the real property, and your debt has to be equal or greater when the day is done. You have no taxable boot from debt. But if you start off with $1 million in debt and you end up with $950 in debt, you have 50 in boot that's recognized as taxable. So real simple rule, more debt and nothing out, and you don't have anything to worry about.
Okay. I like simple rules. And with respect to, in addition to the issue of boot, there's also then the issue of basis. And so the kind of the straightforward rule is that your basis in the property, in your prior property, would then go to the property, the exchange property, right? Or
the famous carryover basis.
Is carryover basis.
What you start with is where you end up.
You do, but to the extent that you you basically receive cash out or receive other property out, then that would, of course, again, that would reduce your basis. And to the extent that you have tax on that property, or rather on the income or the value of the property that you receive, then that would increase your basis. So kind of a simple rule there is it's carryover basis, and then a reduction in basis for income, or for cash rather, and property received, increase in basis for with respect to the extent that you recognize that as income. So
Yeah.
there's
No matter
more
how hard you try, you're likely to end up having some issues because especially if you're in the city of Los Angeles and you have property of any degree of value, you have some of these taxes, which we'll talk about in a little bit, which kick in no matter what. And so somebody's likely to be putting in more cash. So you're likely to have an increase in basis.
Right. And so it gets complicated when you're introducing other parties as well.
Okay.
So go ahead.
Yeah, I don't know why we stuck qualified intermediaries here.
I
That
do not
really
know.
goes with, and I'm the one responsible for it, so I apologize. But the qualified intermediary is the person you bring in on a delayed exchange. You sell your property to the QI, and the QI holds it. And eventually the QI is the one who has to give you back the property or the new property, the replacement property. And there are title companies that have QI companies or exchange companies. Be careful who you select as a QI. There are no licensing requirements, so anybody could set up shop. There has been a couple of these QIs that have gone bankrupt. There's no FDIC type of protection. They may say they're licensed. They have a business license. They may say they're bonded. They may have a couple $1 million bond, but if they're an active QI, they could have, hundreds of matters going at the same time. And so you got to do some due diligence here. Otherwise, if a QI goes solvent and you were the person who introduced them, somebody may be knocking on your door to make them whole, your ex-client. So something to be careful with.
Refinancing and recapture traps before we then get over to the excitement of the clawback.
Well, what happens is if you have boot, you have recognized gain.
Yes.
And what do? You're kind of stuck. One of the things that people don't often think about is boot. Like I said, if your mortgages are the same, you're okay. Well, what if you mortgage up a property just before the exchange or right after the exchange, you suck out money? Both the IRS and the FTB look at those pre-arrangements and say, maybe you didn't quite meet the debt for debt rules, and they will look at them differently and analyze them differently. So some people say 6 months before, some people say 90 days before. Just don't have a pre-existing plan on either side that you're going to refi in order to pull out money.
Okay.
And if you end up with recapture, remember your first dollars are not going to be capital gain. You're going to end up with your 1250 recapture if you have boot. And you're going to get hit in the head with all these other types of taxes that kick in on recognition of income. For example, in California, we have the Rob Reiner mental health tax, which was the 1%, which brings your 12.3% up to 13.3%. And then the Rob Reiner tax now has been expanded beyond mental health, and it goes to substance abuse and housing and all kinds of other things.
Okay.
So suddenly you end up with a lot of issues where you didn't think you had any.
All right. Suzanne, could you take us to the next one? And we're going to pick up the pace here. California clawback. Thank you. And thank you, Howard, for that explanation. And this is an area where California departs. This is a significant departure from federal law. So we had previously described reporting requirements with respect to these exchanges, and we noted that feds have there is an IRS form for reporting on for federal income tax purposes, Form 8824. We noted that presumably California would be, or the FTB would scrutinize these. We noted that there is a withholding requirement on the California side where we would submit a certification that withholdings are required because this qualifies. But that had to do on the California side, we were discussing exchanges that were sold in California. As we have heard, many people have left California and or are investors outside of California. So this is something that really is going to impact a significant number of people. And where California is very interested in maintaining California treatment of with respect to non-recognized income going forward. So to the extent that someone thinks, well, I'm going to move to another state and I'm going to be treated differently in that state, that is not the perspective of the state of California, which tracks the property until the property is sold. So and when one enters into a like-kind exchange and the replacement property is property outside of California, there's also the requirement to file what is called an FTB Form 3840. This sets forth information with respect to exchange, including basis, the gain that was deferred, property descriptions, and so forth. QIs that, as Howard has already kind of described, the qualified intermediary. And this is a form that is filed on an annual basis every year until this deferred gain is fully recognized. And the failure to file the FTB Form 3840 in a particular year can allow the FTB to come in and recognize income at that point, recognizing at that point. So the exchange treatment would be done at that point. And in addition, there could be exposure with respect to penalties, failure to file penalties. Could be interest from the failure to report the tax or from non-payment of tax. And there's also withholding and the implications of failure to withhold. So this is a huge demarcation or departure from the federal treatment. And it's obvious the feds are just worried about the feds, but here California is very interested, and pursuant to the statute, this will be followed again until gain is recognized. And my last comment before then turning it over to Howard on this is that, as we know, there is a basis step up at the death of the taxpayer. So presumably, at that point, you would think that the gain, which there would not be gain at that point, where you would the basis step up. But there, as you'll note from the handout, I guess there's some have some slight question out there as to whether it's possible that there would be a clawback at that point. But California does conform to the feds, certainly with respect to basis step up, and it would seem to me that there would not be tax. But some have noted that may still be an open question. What do you think, Howard?
Analytically, you get the step up in basis. There should be no gain.
Yes.
And one of the questions is, well, what do you file at that point with the last tax return? I mean, so I don't know how you close it out, and I don't think anybody's really thought that through, and the state certainly hasn't issued any announcements on that.
And this is pursuant to Revenue Taxation Code 18032. So, I would anticipate that we'll be hearing more and more about this particular provision. I'm not sure how many people would know about this, but this is incredibly important for anyone who is exchanging outside of the state.
And what's going to happen is at some point you're going to have some case law on this, especially constitutional challenges, because this prevents the free mobility among states, interstate commerce it impacts. So it may not stand the test ultimately. But at the moment, it's the law, and you have to advise your clients of it. And it's just one of those problems that you will face no matter what.
Absolutely.
And it's not unheard of, because the IRS has had this at the federal level. If you expatriate, when you have installment sales, for example, or like-kind exchange and other things, they claw it back.
Mm-hmm. And if you have more than one property, you're going to have more than one FTB Form 3840 requirement, because the question is really going to be, or the interest is going to be in tracking the gain throughout the years. So the more of these you have, then the more reporting requirements you have. And again, the failure to file has huge implications. and also for withholding. So you want to keep all of that in mind when you're thinking of transactions outside of the state of California. So I know that we only have so much time, so let's keep moving. And so if we could have the next one, this is drop-in swaps. And this really has to do with instances where people are in partnerships and a partner may prefer to will want to have treatment at the partner level. And so in this instance, what can happen is they'll have the partnership will distribute the property and then the partner will exchange that property. And what we have here is just kind of a few rules with respect to holding periods. It's incredibly important that these holding periods are met. So with respect to the drop, again, would be the distribution of the property, of the tenant common property to the partners. And the swap would be after you would hold, you'd have the exchange, and then you would hold again as an investment for at least 2 years before recontributing to any entity. So I think that, go ahead, I'm sorry.
The drop-in swap is how you're in a partnership with somebody or multiple parties, and you want to exchange, they want to sell. They want to be out of real estate. Maybe their goals in life are different than yours. Mm-hmm. And so what do? And there are a myriad of mechanical problems. It's real simple. They say drop and swap. So you drop down your undivided interest. LaVonne and I own Blackacre together. We are equal co-owners and make them thirds. And there's a third person in here. So I take my third, we drop it out, and I become a co-owner with LaVonne and the other person. Well, I need a co-ownership agreement. Is my lender going to allow this to happen? Don't know. We now go and, quotes, sell the property. So we need part of the co-ownership agreement has to be a drag-along obligation, where if LaVonne and her partner decide to sell the property, I must sell my interest. But since I own it directly, I can now do an exchange.
Yes. And
that's what the drop and swap is. The swap and drop is the other way around. The three of us as partners, the partnership sells the property and acquires replacement property. We then refinance it. Some people take cash, one ends up with the dirt, and you drop it out.
But we should also
there's a mention here of court holding. Court holding was one of these cases. It's you could look at economic substance. It's sometimes referred to, and sometimes it's referred to as step transaction. In court holding, they were about to sell the property. They had an oral understanding. The tax lawyers came in, looked at the deal, and said, "Oh, there's a way of minimizing tax here and eliminating the corporate level of tax." Under the old rules, if you had a complete liquidation of a corporation, you wouldn't pay corporate level tax, and you only pay a shareholder level tax. So they rejiggered the deal, liquidated the company, dirt goes to shareholder then sold. IRS comes in and says, no, under court holding, we look at your intent. We're back to that intent again. And what was your intent? And your intent was to sell the dirt. So that's where we get these holding periods. They're not statutory. They're what makes sense. What's a good common sense thing to show your intent. So if you hold for a period of time, 12 months, 24 months, 18 months, I don't know what the magic number is. If somebody said 2 years, to me, a December deal, which then puts you to 2 tax years if you hold it for 14 months, 13 months, great. Maybe that's enough.
So court holding really it sets forth that really this is going to be, as Howard indicated, really a substance question and really looking at the substance of the transaction. But also keep in mind at the same time, we still have the other pieces that we have to meet. We still have to, as Howard noted, meet the intent requirements. So even if after partnership property that it becomes tenant in commons property and exchange, the entire time with respect to all of the properties, we're still going to have to meet the requirement that it is held for a specific purpose, for purposes, and that meets the like-kind exchange requirements. And then to the extent that we have exchanges that then again, for out of state, we have to keep in mind the implications for swapping out of state. Howard, I don't know if you have much more on this because we don't have much more time.
Nope, let's move on.
Okay. So related party transactions. So this is just related party transactions. We just have to be very careful when we're dealing with people who are either partners or meet family, meet the definition of family. I'll indicate the code sections that we would look to, but the notion is that in this instance, if property is not held for at least 2 years, then automatically the non-recognition treatment is revoked. As you can see, there is kind of an anti-abuse revenue rule that's also set forth here as well, that we can't use qualified intermediary to try to get around these rules. And also they also scrutinize the transactions where you have kind of multiple steps of transactions. People try to get around these rules in that instance as well. So there's kind of places where we really can have missteps. But what we want to keep in mind is when we have related party transactions, then if either party disposes of the property within 2 years, then the non-recognition treatment fails. So it's very important to hold property. Did you have any comments about Delaware trusts, tenant comment structure?
No, I already talked about them.
Okay, so let's go forward. Why 1031 matters more in California.
Okay, this is just fundamental math. Right. If you do a like-kind exchange, then you qualify and there's no boot, you then escape all of these taxes. California, federal level, if you're subject to tax, you have the long-term capital gain, which you're likely to have, subject to any recapture. You have the 4%, it's less than 4%, 3.8% Obamacare tax. California, the combined tax is 13.3. It's 12.3 plus 1%. So there's an error in the slide there. So the combined is around 38%. It's pretty stiff if you end up realizing tax. So the goal is always how you want to do a 1031 to escape tax. And there are some alternatives. One of the things we'll talk about at another program will be like qualified opportunity zones, where you buy property in an appropriate zone or you develop in an appropriate zone and you can escape immediate tax. Not this year, but next year you'll have a 5-year deferral, and the increase in value over 10 years is tax-free because you get a 10-year step up in basis at the end of a decade. And there's about 270 opportunity zones in and around Los Angeles County. So there's lots of interesting development opportunities to make use of these. And some developers are doubling up and buying in areas where there's transit density bonuses. So some interesting opportunities.
Before we get to the local, and then I know that our time will be up, so I'll make a comment about what remains for your reading pleasure. Wanted to just quick refer to, again, the definitions of related person for the prior issue. So under the Internal Revenue Code, we'd be looking to Section 267B, which covers range of family and business relationships, including members of family, individual, corporation, but you can find definitions there. You can also look to Section 707B1 for definitions of related persons. So you want to look to the Internal Revenue Code, and again, of course, California conforms. At this point, we've done federal and state. Howard's going to mention some local, and then unfortunately our time is up, but I did want to comment that after the local, you'll find a number of pages which I think are very helpful, frankly. It pulls together much of what we've discussed, including practitioner checklists, quick references with Internal Revenue Code, Revenue and Taxation Code, important key takeaways, and then a multi-page list of the federal section or guidance, the California sections and guidance, and where there are distinctions. So unfortunately, we don't have time to go through those with you, but that information is there and hopefully will be helpful. Suzanne, could you go to the next page, please? And I see there's a question there as well, and that person can stay, have an extra minute. We can go ahead and cover that as well.
I just wanted to hit a few local things to think about. Like-kind exchanges is a change in ownership for Prop 13 purposes, and the property is reassessed to its market value. So something to be careful with. There are things like documentary transfer tax. You have to pay them. The mansion tax, over $5 million. Bingo, you get hit in the head with that. It applies. It's a taxable transfer within the mansion tax. So you're going to get hit with that as well. Prop 19, there used to be an exception for $1 million worth of investment property, no longer applies. So you're going to end up with an increase, like I said, in property tax. On personal residences, I have a comment in there about, hold till you die. It's still a viable strategy with the family residence. Hold till you die, get a step up in basis. It'll be revalued for Prop 13 purposes, but you'll have no income tax when it comes time to sell. So very viable. So when you look at a 1031 transaction, be mindful of the local taxes, fees, and charges that you're going to get hit with, because they're not going to be assumed within the 1031. That was the key takeaway there.
It's important. We have one final question here, and then unfortunately our time is up, but there is contact information that has been provided. And so if you have any additional questions, please, do not hesitate to reach out. We have a question here. It says, do the holding rules apply the same to debt? Meaning, if you exchange and have the same amount of debt with the relinquished and replacement property, how long would you have to hold that debt before you could pay it down or refinance without risking the exchange?
Let's start with, you have an issue if you have this plan in mind and set up from day one. But if you have a plan which is, I'm going to wait in your own mind, I'm going to wait for the rates to drop. You do the exchange and the next day the rates drop a half point. Do it. If you have external factors which are motivating what you do, then that justifies doing it quickly. And that's how you could show your intent was to hold. So a lot depends on the specific facts. I'd probably wait a few months. I wouldn't have things in place to refi real quick, but do it and then wait a few months and then pull out some money.
Okay. All right. So I think that takes care of it. It is 1:32. It has been thank you. It has been a true pleasure to be here with you. And sorry that went over a couple minutes, but we really enjoyed it. And again, thank you. So have a good afternoon, everyone. Bye-bye.